Henshaw here again, Constitutional Kook headquarters, and more on what I've recently discovered about the California District Court, noting that this will be true in your jurisdiction too if it's a state admitted into this union. Okay, as I've said, this California District Court exists here. Constitution of 1849 hasn't been repealed. Also in existence is the district judge. And this judge isn't like any judge you've seen in your local quote unquote Cleveland courthouse. This goes back to 1849, 80 years before the state bar was ever around. And this judge is elected by the qualified electors in the various states or districts, as the case may be. Back then, there may have been a district court that covered more than one county, as sparsely populated as things were in 1850. But that said, if we get there, and in California, the county clerk, an elected, ostensibly judicial officer, not controlled by the State Bar Association, is the clerk of that court. And I'm in active communications right now with them, because if we get into that court, that's our constitutional common law court, recognized contemporaneously by the California Supreme Court. And again, what is true here must be true in your jurisdiction, at least up through and including Minnesota, that were admitted to this union up until 1859. Now, I'm prepared, and I'll be doing papers. For those of you that want information on what I do, send me an email, uwinnincourt@gmail.com, for my constitutional defense document packets, which is going to include a jurisdictional position paper that says that these courts are available even in states, quote unquote, admitted after Minnesota, beginning with Nebraska in 1861, since they are fraudulently purporting to be states. And I think that deceit, fraud, and treason is likely enough leverage to get the job done even there. So we'll see about that. But this is such exciting news, because if we get into that court, the perps can't come in there without our permission. And I'll be doing a jurisdictional paper on that too, but they can't think about it, because they've been actively aiding and abetting courts that don't have jurisdiction to exercise it, while preventing courts that have jurisdiction from exercising it. And the U.S. Supreme Court, aka their bosses, has said in Cohen's v. Virginia, 6-week 219, 1818, just cited twice in the last term by the 9 parts, that to do either one of those acts is an act of treason to the Constitution. And it is, and it must be. And in my view, especially if you belong to the State Bar Association, you're already an unregistered foreign agent, likely an agent of the City of London. Those of you who don't know, State Bar, BAR, British Accreditation Registry. So they're out of the mix altogether. And what they should be doing, people out there, is doing what's called a sua sponte recusal for good cause shown when we put our paperwork in. Because we do it and we say it with attitude and with authority, that you judges, quote unquote, don't have any power whatsoever, and for a variety of reasons you're going to love, not the least of which is a irreconcilable conflict of interest, since the local dumbass that you ought to go before is also a State Bar Association member. So where's that neutral magistrate the Supreme Court said we're supposed to have? Toomey v. Ohio, 273 U.S. 510. So we disqualify all of them with no quote unquote judges anywhere in sight. What's left? Your guess is as good as mine. I don't see how they get around this. And I'll report back when I do a bit more research and see what I can find. But this is a subject matter that doesn't seem to have a lot on it at this point. I will get back to you about that. That said, though, send me an email, uwinnincourt@gmail.com, for information about my modestly priced materials. And you can get all of these issues and then some, which is a hell of a lot better than Civil Rights Inc. Jesse Jackson and Al Sharpton. People like you've been on the back of your people all these years for no reason. not wanting to do them any favors because to solve the problems puts you out of business. And we can say the same thing, by the way, for the NRA, also not your friend. All they care about is the Second Amendment right to bear arms. See you later. Ain't, doesn't exist. Bill of Rights doesn't apply to the states. That's the U.S. Supreme Court. Yet again, Barron v. Baltimore, 7 Peters 243. We have much better arguments to make, and now we can maybe actually do it in our courts, which is so much better you can't stand it. That's what the framers ordained and established with the original intent of the Constitution. We're principals and agent relationship here with government actors. We tell them what to do, not the other way around. If we get that back, and it still won't be perfect, there'll be some work to do, but if we do it consistent with the Constitution and not in contravention of it, we will get a long way down the road back to where we should have been, prior to the war between the states. That's the goal. That's my stated objective to get done before I leave here. I got a good 8 or 10 years anyway, maybe a little longer with Family Genes, to see if I can get across the Red Sea and join all of you on the other side when we get back our nation and republic of defined and limited powers. But that said, this district court looks like it has a lot of answers. And right now I'm actively communicating with the local county clerks here, and I prepped a notice of removal of at least one case, and they're going to be getting more of them from what functions as the California Superior Court, quote unquote, into the California District Court, where all our rights are intact and they recognize state citizens, they recognize the value of human life. I mean, it just gets so good you can't stand it. And by the way, those of you that reply, I'll respond with sending you a lot of ancillary information, on my document packets. And it's now going to include the case of State v. Hopkins out of Oregon in 1958. And you read this case, it'll wake you up in a hurry, because the district judge there was complaining, the functional equivalent thereof, that he was out of a job because the legislature in Salem, Oregon, changed the Oregon Judicial Court, the county court, left it intact. The name was the same, but it wasn't a judicial court. It's an administrative agency. Does that sound familiar? It damn well should. And that's what they should tell you from day one when you walk into their courtroom, most particularly when you present the documents from my trial court document packet. More information on that, send me an email, unincourt@gmail.com. We're demanding to know all of these things, to know where the hell we are and why. And most importantly, probably the most 4 important words in constitutional law: consent of the governed. They ain't got any. This is what's going to stop them, because we can prove that it looks like a court, feels like a court, smells like a court, but isn't a court. There are some real constitutional problems here, even in their corrupt system. And Lord knows, people, I should know better. I'm in my 5th decade. I should know better than to get excited about things. But I can't help it here. If all this works and we have it in black and white out of their own mouths, how do you get around that on the record without committing what the Supreme Court has described as acts of treason, as mentioned earlier in Cohen's v. Virginia? I'd love to hear it. So that said, as I say at the close of all my videos, we have to stop, all this divide and conquer crap they've been doing for at least 150 years. Get on the same page, Asians, Africans, Americans, all of us, with the right issues, the right courts, and we'll get these bastards off our backs. Remember to subscribe, like my videos, tell your friends, get the word out. The quicker we take action, the quicker these bums are going to be out of our lives and we get back to what we should have. How good is that? Thank you.